Okay, thank you everybody for coming to this final talk, which is on lasting power of attorney. And the reason that we added this to the Headway series is this is something that comes up frequently for patients at the Sussex Rehab Centre and also for their relatives. So at the moment, I'm trying to assess two patients who are looking to set up lasting power of attorney. And often people don't think about this too much in advance. I think something like 10% of the population has set up lasting power of attorney. A lot of people think that their next of kin can do various things for things like health and welfare, and then discover that actually next of kin doesn't really have particular legal standing. And when it comes to finances, things like paying bills and accessing bank accounts is obviously very difficult if you're not the account holder. And so this is why this comes up as somebody is joining us here at SRC. Okay, so two parts to talk today, and for part one we're going to talk about what lasting power of attorney is. What is it? Why would I want it? And alternatively, if you are the attorney appointed, what do I have to do if I agree to be someone else's attorney? So the general idea of lasting power of attorney is it allows someone whom you, the donor, have chosen and appointed to make decisions for you and to take action for you when you are not able to do so. There are some caveats to this, which we'll come on to. There's two types of power of attorney. The first one is health and welfare. This can cover things, anything from your daily routine, so what time you might like to get up and get out of bed, what you might like to have for breakfast if you're not able to communicate that yourself. It could be medical decisions. It could be whether you need to move out of your home into a care home. It can be for life-sustaining treatment, although that is a separate part of the form. So not everyone chooses to ask the donor to make decisions on life-sustaining treatment. You can have that as an either-or option within this power of attorney. If you don't have power of attorney for health and welfare, then either doctors and or social workers are ultimately the decision makers, not your next of kin. So your loved one should be consulted about important decisions. And if everybody is in agreement, there's not usually a formal best interest meeting. But if it's not certain that everybody's in agreement, there should be a formal best interest meeting with minutes held to reach these decisions. However, in the end, the ultimate decision would come down to the consultant or your social worker. This power of attorney only comes into effect when you lose capacity to make decisions for yourself. Otherwise, you would just be asked yourself what you want. The other type of power of attorney is for property and financial affairs. This can cover things from managing a bank account, paying bills, collecting benefits or a pension, all the way up to selling your home. So with this power of attorney, you can choose for it to only come into effect when you don't have capacity to make these decisions yourself. Or if you want to, you can choose to allow your attorney to act upon it straight away. Obviously, they should be asking what you want and only acting upon your wishes when you've got capacity. For the patients here, quite often if they choose to have it be activated all the time, it's due to convenience. So perhaps with mobility difficulties or being an inpatient, they might be capable of going to the bank and sorting out their bills. Apart from it's not easy to get to the bank, and it's not always easy to speak on the telephone if you've got aphasia or difficulties. So it could be you can communicate to your attorney what you want, and then they can go and action your decisions. If you don't have a power of attorney for property and financial affairs set up, it's not always clear who can make the decisions for you, and it can get quite complicated. So it can be down to certain departments in social work, but social work departments are always very busy. So that isn't necessarily that easy to access in my experience. Relatives, the banks won't just let your relatives go in and access your accounts for obvious reasons. So your relatives or loved ones may have to apply to the court protection to become a deputy. Then they have to pay an annual fee and get audited. Or you might choose to pay a professional solicitor to be your deputy, or the court may appoint a professional solicitor to be your deputy if you're not able to choose your deputy. And there are obviously costs involved to this choice. So we'll talk a bit now about the Mental Capacity Act and why that's relevant to the decision making around power of attorney. So the Mental Capacity Act protects people's right to make their own decisions, even if other people think those decisions are unwise, as long as they can understand and weigh up their options and communicate what they want. So this sets out how people should be supported and protected as well, and sometimes from their own decisions that they've not fully understood, if a person can't understand or weigh up information and communicate their decisions. So this act simultaneously lays out where people should be able to make their own decisions, even if others don't agree that it's that wise, and what should happen for somebody who has an impairment of brain or mind, as it's called, who therefore, because of that, cannot understand or weigh up the information for that particular decision or to communicate that decision. There are 5 principles to the Mental Capacity Act, and the first 3 are particularly relevant to this talk. So first of all, it should be assumed a person has capacity unless proved otherwise. So sometimes at Sussex Rehab Centre, we have patients that are here for spinal injuries or for a stroke that has mainly affected their movement and not their cognition. And if they choose to set up power of attorney, that's therefore nothing to do with us, and we would just okay for them to have somebody come to the ward to certificate provide with them. However, if somebody does have cognitive difficulties and we think that they would need to be formally assessed to sign power of attorney, then that's something that we would potentially get involved with. Another reason for us to get involved in that is this second principle of the Mental Capacity Act, which is do not treat people as incapable of making a decision unless all practical steps have been tried to help them. And those steps can involving a specialist speech and language therapist and or a neuropsychologist to help support communication and cognition. So it could be that if someone's just presented the information in the standard format of the government website, they're not going to be able to access that. But if you can break it down in ways I'm going to come on to, then that could be more accessible to them. The third principle is that a person should not be treated as incapable of making a decision just because others think that decision may seem unwise, which we covered briefly before. There's 2 other principles that are less relevant to this assessment because you can't sign power of attorney on somebody's behalf. You have to apply to the Court of Protection for a deputyship. So thinking about why the Mental Capacity Act is relevant to lasting power of attorney, somebody needs to have capacity to sign lasting power of attorney in the first place. It's a legal document with consequences, both for health and welfare and for finances. And so somebody needs to know what they're signing before they sign this important legal document. Sometimes power of attorneys may only come into effect when the person loses capacity to make those decisions. So as we've discussed, it can be otherwise for power of attorney for property and financial affairs, but certainly for health and welfare, someone would need to be assessed as not having capacity to make those decisions in order for their attorney to step in and take over that decision-making process. And with all decisions assessed under the Mental Capacity Act, a person rarely loses capacity altogether. So each assessment is decision specific. There can be exceptions to this. As the rule of thumb is, it's not possible to be told you've lost capacity. But if somebody is in a coma and they're not able to wake up and communicate any kind of decision by any means, then it doesn't matter what question you ask them, they're not going to be able to give you an answer.